In March of this year, now Justice Ketanji Brown Jackson sat before the Senate Judiciary Committee for confirmation hearings for her historic nomination. Jackson, who would be later confirmed by a 53-47 Senate vote, made history as the first black woman and first former public defender to sit on the high court. In her confirmation hearing, sparks flew, courtesy of Republican inquisitors like Senator Tom Cotton. Cotton repeatedly pressed Jackson on her record as a judge, a lawyer, and on her stances concerning crime, sentencing, drugs, and critical race theory. Cotton, a hardline conservative, slammed Jackson's record, claiming it reflected a lenient attitude toward criminals and embraced far-left social ideas. Democrats pushed back on such accusations, claiming Jackson was in the mainstream and she was being smeared by GOP critics. The Arkansas senator ultimately voted not to confirm Jackson to the Supreme Court.
And next up is the senator from Arkansas, Senator Cotton, for opening statement.
I welcome Judge Jackson and her family, and I congratulate her on her nomination. This is an important occasion. The Biden administration is waging a war on the rule of law, the separation of powers, and the Constitution. The lawlessness of the administration highlights the importance of judges who faithfully apply the law. To understand the ongoing power grab, let's consider President Biden's failed nominee to lead the Departments of Justice, ATF. The man he nominated can only be described as an anti-gun zealot. Thanks to the courage of some of my Democratic colleagues, that nominee was withdrawn. But it's disturbing that the president was ever willing to nominate someone who planned to shred the Second Amendment and ban virtually every modern hunting rifle in America. Just a few weeks ago, the Biden administration tried to twist the authority of the Occupational Safety and Health Administration, a relatively obscure agency designed to regulate things like ladder safety on construction sites, and use it as a weapon to force virtually every American to choose between getting vaccinated or losing their livelihood. Thankfully, the Supreme Court struck down that unlawful power grab. Or look at the southern border, where Joe Biden and his Secretary of Homeland Security steadfastly refused to enforce our laws. As a result, 2 million illegal aliens streamed across our borders just last year. And less than 6 months ago, the Attorney General of the United States, himself a former judge, ordered that federal prosecutors, the FBI, and even the National Security Division of the Department of Justice be mobilized against parents who dared question the entrenched teachers' unions who are poisoning their children with racist vitriol known as critical race theory. As Justice Scalia was fond of saying, every banana republic has a Bill of Rights, but it's nothing more than a parchment barrier without free and fair elections, without separated powers, without the rule of law, and without an independent judiciary to uphold it all. Perhaps recognizing what Justice Scalia meant, the progressive left is not just threatening the rights of Americans, but our very system of constitutional government. Those on the left, including some of my colleagues here in the Senate, including on this committee, want to pack the Supreme Court. I would hope that anyone nominated to the court would have no problem echoing the words of Justice Ginsburg and Justice Breyer. Both of these liberal lions have said that expanding the Supreme Court to achieve favored legal and political outcomes is a dangerous idea, and that the court should have 9 justices and no more. But for some, political outcomes on the court are exactly their goal. The Democratic leader, Senator Schumer, stood on the steps of the Supreme Court almost exactly 2 years ago and yelled at specific justices, quote, "You have unleashed the whirlwind and you will pay the price," and added, quote, "You won't know what hits you if you go forward with these awful decisions," end quote. The Chief Justice rightly condemned these words. Again, I hope any nominee to the court would be comfortable condemning these words from Senator Schumer as well. The Supreme Court is not the only constitutional limit on power that the left would like to destroy. The Associate Attorney General of the United States has said that she believes that every single American, and every single institution in this country are inherently racist, and that the very concepts of the rule of law and equal justice for all are actually, quote, code words. That's what she said, code words for some kind of twisted, secret racism. These threats to the rule of law are not merely theoretical. We are witnessing a breakdown of society. There are many Americans who no longer feel safe today. Parents are scared to walk down the streets that used to be free from crime. In 2020, anarchists, rioters, and left-wing street militias raged across the country, and murders increased at the fastest rate in history. And in the first year of the Biden administration, violent crime got even worse. It's no coincidence that this violence came as localities and states pushed to defund the police and reduce the punishment for criminals. Career criminals are committing violent crimes and going free under the guise of a supposedly more equitable justice system. And liberal judges who have more sympathy for the victimizers than for the victims are a big part of the problem. The Biden administration is committed to these soft-on-crime policies, like ending cash bail to create a catch-and-release system for violent criminals. Progressive Soros prosecutors who are supported by the Biden administration have nullified entire sections of law to destroy our criminal justice system from within. The consequences are obvious. Skyrocketing violent crime, emboldened gangs, and drug overdoses reaching numbers never before seen in American history. If Judge Jackson is confirmed, her decisions will have a direct impact on the safety of the American people. So we're going to look at her past decisions and her statements, because the best predictor of future performance is past performance. That brings us to today. We're asked to determine whether the President's nominee to the Supreme Court is able and willing to meet these vital challenges. I enjoyed meeting with Judge Jackson last week in my office. We had a good conversation, and over the next few days, I'll have many more questions. Let's be clear about this. The confirmation hearing is not a test of how well nominees can filibuster or how many questions they can avoid answering. It's true that there is a tradition of avoiding any stances on how one might rule in specific cases, if confirmed, and there's good reason for that. But that's not a license to refuse to discuss one's views of the law, how one would go about conducting legal interpretation, or one's philosophy as a judge. Judge Jackson isn't nominated to be a district judge or a circuit judge this time around, so it is not enough to say that she will approach things with integrity and fairness and faithfully apply precedents set by higher courts. Just as you wouldn't hire a teacher who refused to say anything about their teaching philosophy other than that they would look at the curriculum and appropriately teach the students, it's not enough to say only that one would look at the facts and arguments in the case and fairly apply the law. That wouldn't tell us anything about how one plans to do the job, how one interprets the law, how one understands our Constitution. It's no secret that I voted against Judge Jackson's nomination to the Circuit Court last year, but I want to give her the opportunity to show why I should vote for her this time. So I want to be clear about what would convince me to support any Supreme Court nominee. I'm looking for a justice who will uphold the Constitution, not use it to invent new so-called rights. I'm looking for a justice who understands that the Constitution means what it says and does not mean what it doesn't say. Someone who understands that it is not up to 9 unaccountable, unelected politicians in black robes to decide some new evolving meaning of the Constitution based on public opinion polling or views of the legal elite. I'm looking for a justice who realizes that a so-called living Constitution really means that the Constitution is dead. Instead, we should have an enduring Constitution, as Justice Scalia contended. I'm looking for a justice who understands that there is a process for updating the Constitution, and that process is by amending the Constitution. I will not support anyone who seeks to rewrite the Constitution from the bench, rather than through our constitutional amendment process. I'm looking for a justice who understands that nobody is above the law and will not coddle criminals or put illegal aliens ahead of American citizens. I'm looking for a justice who will protect the right to life of innocent infants instead of caving to the abortion lobby, creating whole new swaths of law out of whole cloth. I'm looking for a justice who will make decisions based on the law, not based on their personal experiences or preferences, not on empathy, not on desired political outcomes, but on the law and the Constitution. If Judge Jackson is confirmed, her job will be simple: leave the legislating to Congress and to elected, accountable office holders in our states and our municipalities. Zealously protect the separation of powers and don't overturn laws unless they violate the Constitution. Judge, I'd like to talk about crime. In 2019, there were about 16,000 murders in America. In 2020, there were more than 20,000. That's a 25% increase in 1 year. 2021 data isn't complete, but we know many cities have reached record levels of murder, including Philadelphia, Atlanta, and Milwaukee. At the same time, the prison population has decreased by about 14%, in part from pandemic policies, but also from fewer prosecutions and weaker sentencings. I think it's safe to say that there's a surge in crime, especially violent crime and murder across America. You have noted that some members of your family have law enforcement backgrounds, and I honor them and thank them for their service. Does the United States need more police or fewer police?
Thank you, Senator. As you just noted, I have law enforcement in my background, and I am very familiar with the problems that crime cause in the communities where we live.
Okay, Judge, I'm sorry. We have a few minutes here. You have a lifetime appointment if you're confirmed. I asked a simple either-or question. Does the United States need more or fewer police?
Senator, the determination about whether there should be more or fewer police is a policy decision by another branch of government. It is not something that judges have control over, and I will stay in my lane in terms of the kinds of things that are properly in the judicial branch.
Okay, if you don't want to address whether the United States needs more or fewer police, we'll move on to sentencing, which is certainly in your lane. There's been a lot of talk about criminal justice and sentencing approaches and theories today. In general, is someone more likely or less likely to commit a crime if they know that they will be caught, convicted, and sentenced?
Senator, what is in my lane is the consideration of particular cases of
Judge,
prosecution.
You've spoken a lot today about criminal sentencing, about the theory of sentencing. You've written a lot about it in your record. It is a very simple question. Is someone more likely or less likely to commit crime if they're more certain that they're going to be caught, convicted, and sentenced?
Senator, I am aware from my work on the Sentencing Commission and not as a judge that there is research into recidivism rates, into rehabilitation, into the factors that go into a determination about whether someone is more or less likely to commit crime. Part of what Congress has taken into account when it determined that one of the purposes of punishment is deterrence is the idea that if someone is convicted and punished, they will be deterred from committing other crimes.
And you've mentioned that, and you've written about that in your writings. There's 4 purposes of punishment. One of those is deterrence. Isn't it inherent in the concept of deterrence that people are less likely to commit crime if they're more likely to get caught, convicted, and sentenced? Why can't you just say that's the case?
Senator, it's not that I'm avoiding saying that's the case.
No, Judge, that's exactly what you're doing. I'm asking a very simple question. In general, is someone more likely or less likely to commit a crime if they know they're going to be caught, convicted, and sentenced?
It's the
heart of deterrence theory.
It's very difficult to answer questions in general when you're asking about things like phenomena related to crime. It's the theory behind deterrence that by punishing someone, they will be less likely to commit the crime in the future. That is a theory that undergirds.
Do you think that theory is correct?
Senator, there is research that supports that deterrence is something that can occur. Does it occur in every case? I can't say that.
Okay, let's turn to something more concrete then. Do you know how long the average inmate convicted for a murder serves in prison in America?
No, I don't.
The answer is 17 years on average. Is 17 years too long or not long enough for a criminal to spend in prison for murder?
Senator, these are policy questions, whether they're in the province of the Sentencing Commission in terms of recommendations, whether they are in Congress. They're not the kinds of things that I can opine about.
So you don't want to opine on whether 17 years is too long or too short a sentence for murder?
Senator Cotton, the Congress has prescribed a number of factors that judges look at when they sentence. It may, in many cases, not be. I can't answer in the abstract in the way that you.
Well, these are very concrete. Let's turn to rape. Do you know how long the average inmate convicted of rape serves in prison in America?
Well, Senator, rape is not a crime in the federal system that I'm familiar with working with, so I don't know.
It's 7.2 months. Do you think 7.2 months is too long or too short for someone convicted of rape to be sentenced to prison?
Senator, that's a policy question about the egregious crime of rape, and Congress has said that the court is supposed to take into account a number of factors when it sentences.
Okay.
I can't answer in the abstract.
Well, Judge, these are not abstract. These are very concrete. And remember, these are just the length of sentence if you're caught, convicted, and sentenced. Let's look at cases in which people are never caught. As I said, in 2020, murders increased by the fastest rate ever in the United States. Do you know what percentage of murders are solved in America?
Majority of cases.
I do not, Senator.
The answer is about half, 54% in 2020. Do you think we should catch and imprison more murderers or fewer murderers?
Well, Senator, it's very important that people be held accountable for their crimes. So that is a fundamental tenet of the rule of law.
So is that a yes, we should catch more murderers, specifically the 46% of murderers who get away with it?
Senator, I'm not, to the extent you're asking about enforcement or law enforcement, those...
Judge, it's a very simple and common sense question. 46% of all murders go unsolved. Should we catch more of those murderers or should we catch fewer of them?
Senator, we should hold people accountable for their crimes. And so if people are not being held accountable, then that is a problem.
Let's turn to assaults. Do you know how many assaults were solved in this country in 2020?
No, Senator.
44%. So 56% of all assault victims did not receive justice. Do you think we should catch and imprison more criminals who commit assault against innocent people or fewer?
Senator, it's very important that people be held accountable for their crimes. So if they're not, then it would be a problem for the rule of law.
Let's look at sexual assault and rape. Do you know what percentage of sexual assaults and rapes go unsolved in this country?
I do not, Senator.
77%, more than 3/4 of all sexual assaults and rapes go unsolved. Do you think we should catch and imprison more rapists and sex criminals or fewer?
Senator, one of my two uncles was a detective in a sexual crimes and battery unit. So I'm very familiar with that type of crime. It's a horrible type of crime, as are all of these that you are articulating. And it is important for people to be held accountable for criminal behavior. It's fundamental to the rule of law.
Okay. So in 2020 alone, well over 1 million violent crimes went unsolved in America. Do you think we imprison too many violent criminals or not enough?
Senator, it's important for our rule of law to ensure that people are held accountable who are breaking the law in the ways that you mentioned and otherwise.
What do you think the families of all those victims think? Do you think they think that we should arrest and convict and sentence all these criminals who get away with it?
Senator, I know what the families of law enforcement officers think because I'm one of them. I know what crime does to our society. I care deeply about public safety. And as a judge, it's been my duty when I was at the trial level, I'm no longer there, but when I was at the trial level, to ensure that people are held accountable for their crimes.
Okay. Let's turn to the crime of child pornography. I know there's been a lot of talk about it today. I don't want to spend much time on it. A lot of people have tried to explain the various differences in these cases and the pre-sentencing reports and the sentences that they got. So let me just ask you a simple question about it. Should the United States strengthen or weaken sentences for child pornographers?
Senator, that's not a simple question, and the reason is because what this country does in terms of penalties is in Congress's province. You all decide. You all decide what the penalties are. You decide what the factors are that judges use to sentence. If you determine that any set of penalties is insufficient, then it is in your purview to make that determination. There are many crimes that Congress has determined warrant mandatory minimum penalties, warrant other kinds of penalties, and that is in your purview to determine.
I have to say, Judge, I think whether or not we should strengthen or weaken sentences for child pornographers is a pretty simple question, but I'll move on. I think the difference we've heard today gets to this simple fact that a bunch of elite lawyers, whether they're judges or federal prosecutors or public defenders or law professors, think that sentences for child pornography are too harsh. I don't, and I bet a lot of normal Americans don't either. You've said repeatedly that sentencing is a discretionary act, and I understand that and I agree with it. But you always seem to use your discretion in these child pornography cases to reduce the sentences. I have to say, if I had that discretion, I'd probably throw the book at child pornographers. Maybe that's just me. But let's turn to drug crime. Last year, more than 100,000 Americans died from drug overdose. Drug overdose deaths and gang crime have both skyrocketed in recent years. At the same time that a lot of soft-on-crime laws and lower sentences have been advocated, including, on occasions, Judge, by yourself. In general, do you think the United States should weaken or strengthen sentences for fentanyl traffickers? Traffickers, not users.
Senator, whether or not Congress chooses to strengthen or weaken penalties for any crime is a determination of this body, which is ordinarily made after study and review, determination. That is in the province of Congress.
Well, Judge, you've said before that sentencing is a discretionary act, so that is literally the job of the judge in many of these cases to determine whether to have a shorter or a longer sentence.
Respectfully, Senator, the judge makes that determination not based on one data point in general, which is what you asked me. In general, should we lower or heighten sentences? A judge is making a determination in a particular case, looking at all of the factors. It's discretionary for sure, but we do so within the bounds of a sentencing range that Congress prescribes. And at times in which Congress decides that a penalty needs to be heightened, they impose a mandatory minimum. Then our range is shorter. And when we're looking at the crime, we're not looking as a policy matter across all fentanyl crimes and determining whether the penalty should be increased. As a judge, we are asked in the context of a single prosecution regarding a particular person who has committed a horrible crime, but also, says Congress, is a person who has a life, who has a job, who has all of the other factors that Congress has told judges they have to look at when they decide what penalty to impose in that particular case between the range that Congress sets. So it's not a situation in which I can, in my role as a judge, tell you as a general matter whether penalties should be increased or decreased.
I have to say, I think that not many Americans, especially not the 100,000 Americans who's lost someone to drug overdose, think these are tough questions. But let's move on. Let's talk about retroactivity. When you were on the Sentencing Commission, you repeatedly advocated for retroactively reducing drug trafficking sentences. So this is a case where a drug kingpin who's dealing fentanyl gets sentenced, and then a few years later, he gets lucky. He gets in front of some new judge who's maybe more sympathetic and thinks he got a raw deal, or maybe he just gets in front of the same judge a few years removed from seeing the faces of the victims of his crime. Do you believe that resentencing years after a conviction tends to reduce sentence lengths?
Senator, respectfully, I just wanted to remark on your previous question and your statement that these are not difficult questions. It's not that they're difficult questions, it's that they're not questions for me. I am not the Congress. I am not making policy around sentencing. My job is to look in a particular case and decide what the penalty should be within the range that Congress prescribes.
I understand. You were making policy, though, at the Sentencing Commission, and you're implementing changes to sentencing guidelines. So my question again is, do you believe that resentencing years after a conviction tends to reduce sentence lengths?
I'm not sure I understand your question. Obviously, if you resentence, you're giving the judge another opportunity to look at the circumstances in light of the changed penalties. Sometimes the judge in that new situation will keep the same penalty. A resentencing is just an opportunity for the judge to reevaluate in light of the changed circumstances.
Okay. Almost without exception, retroactively weakening sentencing laws and guidelines lets harden criminals out early. I always hear the argument, I hear it from some of the senators on this panel, I heard a version of it from you earlier, that each case is going to go before a judge and it won't be an automatic release because each judge is going to assess the facts and hear the arguments. In 2014, you said that judges would not likely reduce the sentences in the vast majority of cases if sentencing guidelines for drug trafficking were reduced. I think you missed that one, Judge. Since 2014, when retroactive reduction took effect, approximately 2/3 of all convicted drug traffickers who asked for early release got it. That's 31,614 hardened drug traffickers back on the streets. More than 7,500 of those hardened drug traffickers use weapons in their crimes. So that means that only 1/3 of these drug traffickers who sought to have retroactive reduction of their sentence were denied. Judges, 1/3, a vast majority.
Senator, it's hard for me to answer questions about these numbers because I'm trying to understand whether this is a retroactive release that was a result of the Sentencing Commission's actions or Congress's. Congress made a decision about retroactive reductions in drug penalties. So I'm just not sure what.
But Judge, in both cases, we always hear the argument, whether it's from members of Congress to include senators on this committee or the Sentencing Commission, that we shouldn't worry, there's going to be individualized case-by-case determination.
And that is my experience. That's when there is a retroactive change. So what happens is that whether it's the guidelines that are changed or the laws that are changed, which happens in Congress, there is a subsequent determination as to whether or not to apply that retroactively, apply that change, so that both the people who get convicted of that penalty moving forward and the people who have already been convicted, both of them get the benefit of the change if the determination is made to make it retroactive. Under that circumstance where you're talking about a penalty change applied to prior people, each one of those prior people goes back before a judge, and a judge, usually the sentencing judge in the first instance, will reevaluate whether or not to, this is generally, there are some exceptions, but generally speaking, the judge will reevaluate whether or not to give that person the benefit of the change. This is an individual assessment. That's what Congress requires in every sentence, and ultimately one that benefits all of us under the law, because judges are being asked to look at these cases and not make just generalized determinations.
So the 2014 comment was specifically about the Sentencing Commission, but generally, whether it's in front of the Commission or the Congress, we always hear this argument that judges are going to make these individualized cases and not that many people will be released. I'll point out that of the 1/3 that were not reduced, the vast majority of those were not eligible. The percentage of cases in which a sentence is not reduced for public safety reasons because someone is viewed as too dangerous to release early is 1%. It's 1%. Judge, do you remember a man named Keith Young?
Yes.
Good. For the benefit of my colleagues, let me quickly cover the basics of his case. You sentenced him in 2018. Keith Young was a career criminal who had previously been convicted of trafficking cocaine. In 2017, he was running a drug business in his house where his children lived and was found with 2 1-kilogram bricks of heroin worth hundreds of thousands of dollars, along with a gun, ammunition, thousands of dollars in cash, and equipment to cut and package heroin for retail sale. The drug lab also confirmed that there was fentanyl in both bricks of heroin. And in one of the 2 bricks, there was actually more fentanyl than there was heroin. While at the D.C. jail awaiting trial, Young bragged about his arrest and about how he was a kingpin. Those are his words, not mine. Kingpin. He was even recorded calling his wife and brother to give them instructions on collecting drug money from people for him. The prosecutors filed a notice of Young's criminal history, which meant he faced a mandatory minimum of 20 years. You did not seem to like that, Judge. In fact, at his sentencing, you said, this is a quote, that you shared his frustration, that you couldn't give him a lighter sentence. I was shocked to see this in the transcript. I was also shocked that you apologized to this drug kingpin for having to follow the law. You literally said that you didn't think 20 years was fair. This is the quote, "And for this, I am sorry, mostly because I believe in second chances." You apologized to this career criminal, a drug kingpin. In his own words, he was not some low-level first-time drug offender who made a bad choice. That was in 2018. But in 2020, you got a second chance. After Young's sentence, Congress passed something called the First Step Act, which reduced sentences for serious drug traffickers with lengthy criminal records. During the pandemic, lots of criminals like Keith Young tried to twist the First Step Act's compassionate release provision, which was intended for terminally ill elderly inmates, to get early release and blame it on COVID. You had none of that, and that's good. You rightly said at his resentencing hearing, quote, "COVID-19 is not only present in prisons," and you said that Young's past as a smoker and his claim of various other health issues did not entitle him to early release. If you had stopped there, I would have cited that as a great example of how you follow the law and made a well-reasoned decision. Unfortunately, you didn't stop there. You said in the resentencing that, quote, "Congress did not make their changes under the First Step Act retroactive, but that if they had, then you could have given him a reduced sentence." But then you said, no matter what the law says, and this is a quote, Judge, "The court feels as though in this moment, per Mr. Young's compassionate release motion, the court is being called upon to evaluate the length of his sentence under the revised section of the law in the First Step Act, and so it is almost as if I am sentencing him today. And if I were to do so, he would face a sentence that would be well below the 240 months that Mr. Young received. And so for that reason, I will grant Mr. Young's motion." Judge Jackson, before you granted this fentanyl kingpin's motion to reduce his sentence, did you contact any of the victims from his case?
Senator, thank you for allowing me to address Mr. Young's situation.
I asked a simple question. Did you contact the victims in his case or not?
Senator, Mr. Young was not released. His sentence was reduced, and I did not contact the victims in his case because there were no victims. He committed a crime, a drug crime. There were no identifiable victims in his case.
Drug crime is not a victimless crime. 100,000 Americans were killed by overdoses.
Understood, Senator, but there was no one to contact because there were no identifiable.
Judge, you just acknowledged that you did not release him. You're right, you didn't release him. He filed a motion for compassionate release. You denied that rightly, but you reduced his sentence. He didn't file a motion to reduce his sentence. He wasn't eligible for a reduced sentence under the First Step Act because it wasn't retroactive towards him. You took a motion for compassionate release to get out of prison and turned it into a motion to reduce a sentence. So he's going to be released 7.5 years earlier, years from now. Last week, Judge, when we talked in our office, you talked about a lot about judicial restraint. Is transforming his motion for compassionate release into a motion to reduce a sentence for this drug trafficking kingpin an example of judicial restraint, Judge?
Yes, Senator, it is, and I will explain how. Mr. Young, as you say, was facing originally a sentence of 20 years in prison, which I imposed. I tried Mr. Young, who went to trial, primarily because he was facing such a long penalty. I looked at the evidence in his case. He was absolutely the kingpin that you're talking about. But the way that our laws work, the 20-year sentence that he received for the amount of heroin that he had was increased based on a sentence that he received, I think it was 10 or 15 years before. He had no criminal history between the old sentence, and forgive me, I can't remember exactly what it is, and I'm sure people will look it up. But 10, 15 years before, he had some minor sentence. Then he had this really obviously serious, terrible sentence. And the government filed what is called an 851, which is an enhancement based on his really, really old prior criminal history. I followed the law, which said that he had to go to jail for 20 years. It would have been more like 10 years if the government hadn't taken into account his very old criminal history. But I said, fine, this is the law. I'm following it. You're going to jail for 20 years. In the interim, COVID happens. We get lots of compassionate release motions, and there's a statute that Congress has enacted which allows defendants to seek compassionate release, to seek reduction of their sentence, not just release, reduction, release, some adjustment to their penalty under the law if there are extraordinary and compelling reasons to do so. That's the quote from the statute, extraordinary and compelling reasons. Doesn't say anything more narrow than that, although you do have to look at the guidelines related to compassionate release, all of which I did related to his motion. And he argued several things. He argued his smoking, his asthma. These were reasons, he said, for compassionate release, and I disagreed. What I did find extraordinary and compelling is the fact that between the 20-year sentence that I gave him originally and the compassionate release motion that he filed, Congress changed the law. Congress decided that the old penalty, the old crime, was no longer eligible for the increased, so that a person who was convicted at the time of his compassionate release motion for doing exactly what Mr. Young had done would not get a 20-year sentence. That would not be lawful for a person at that moment. And one of the things that Congress says to the judges is care about unwarranted sentencing disparity. Care about the fact that the person you're sentencing is being treated differently than someone else who committed exactly the same crime. And I understand it wasn't retroactive in the sense that everybody, absent a compassionate release motion, wouldn't have been eligible for resentencing. But here I have a defendant before me and all of the factors that Congress has asked me to take into account, and a compelling argument that there were extraordinary and compelling circumstances, that is, a change in the law, that would create unwarranted sentencing disparity if I didn't take account of it. And so what I determined under those circumstances is that I would resentence Mr. Young to the penalty that Congress had decided was the appropriate penalty for the conduct that he committed as of the time of his motion.
Judge, Congress did change the law after his sentencing in the First Step Act. That was a terrible mistake. Congress specifically did not make that change retroactively. And you saw that, and you thought it was extraordinary and compelling, even though Congress specifically did not make it retroactive. You chose to rewrite the law because you were sympathetic to a fentanyl drug kingpin whom you had expressed frustration at having sentenced him to his 20-year sentence in the first place. You twisted the law and you rewrote it so you could cut the sentence of a drug kingpin. That's what you did, Judge.
Respectfully, Senator, I disagree. Congress provided judges through the compassionate release motion mechanism with the opportunity to review sentences. Congress, prior to the compassionate release mechanism being enacted, a judge who imposed a sentence would have no opportunity to revisit. In Mr. Young's case, the question was, with this compassionate release motion, under a circumstance in which Congress had changed the law, was that an extraordinary and compelling circumstance to revisit his sentence? And I made a determination that it was.
So I suppose then, if you're confirmed, we can just count on you to always rule in favor of retroactivity, no matter what the facts of the case are, because it was a blatant rewrite of the law here, so you could reduce the sentence of a drug kingpin if you didn't like sentencing to 20 years in the first place.
No, Senator, it was not.
Senator Booker.
Judge, I want to return to the question of crime and specifically sentencing. In any of the cases where you've sentenced an offender below the guidelines, has that offender gone on to commit another crime after getting released from prison?
Thank you, Senator. When judges sentence, they often impose terms of supervised release, and there are times in which, when a person is on supervised release, they reoffend. There are also times when they don't. But even after the period of supervised release, the court doesn't continue to have any way of tracking or knowing what happens, because if they were to reoffend, it wouldn't necessarily come back to the same court or the same judge.
So you don't have a factual basis to know whether or not anyone you've sentenced below the guidelines has reoffended in the future?
Do I have a factual basis? I know that there are people who have reoffended while on supervised release. I can't remember whether any of them were guideline sentences, below guidelines, or above guideline sentences.
Okay. I know you've answered a lot of questions the last 2 days about sentences and sex crimes. I just want to be exact about this. In these cases, have you ever sentenced an offender above the guidelines recommendation?
I'd have to take a look at, I know that I have sentenced offenders to the guidelines if in the category of sex crimes in general. I know that I've given 30-year sentences for at least one offender, almost 30 years, 29.5. I've given, I believe, a 12-year sentence for someone at the agreement of all of the parties, which was a sentence that was a part of his plea agreement. I'm not remembering the others.
I understand you've sentenced in a lot of cases. I want to return briefly to the Hawkins case. Wesley Hawkins, as a reminder, was convicted of a child pornography offense in 2013. The sentencing guidelines for this offense called for a sentence of 97 to 121 months, or 8 to 10 years. The prosecutors asked for 24 months. You sentenced him to 3 months. We've heard a lot about this case and your 3-month sentence. of Wesley Hawkins, but you got another crack at him in 2019, Judge. In 2019, you sent Wesley Hawkins back under conditions of confinement with the Bureau of Prisons for 6 months with additional restrictions on his computer usage. That's twice the amount of time in custody that you sentenced him to in 2013. What did Wesley Hawkins do in 2019, Judge?
Oh, I don't remember, Senator. I have a lot of defendants who I've sentenced who are on supervision, who violate conditions of supervision. If in our system, someone like Mr. Hawkins, especially given the crime, the egregious crime that he committed, was likely on a very long period of supervision. And during that time, he would likely be under computer restrictions for 10, 20 years or something, where he's not allowed to do certain things with a computer. And a probation officer is monitoring. They put software on the computers of individuals who are who have these kinds of conditions imposed, and that restricts their ability to access certain information on the internet. And so it's not uncommon for a probation officer to report violations of supervised release, not just in this area, but across all crimes. And then the court has to determine how to handle that. And you could, in fact, send someone back to jail for violating conditions of supervised release that are not themselves criminal behavior. It's just, the court says in their supervision order, I'm imposing a 20-year or whatever it is sentence of supervision, and during this time you're not allowed to access your computer, et cetera, et cetera. So if he were to do that, it wouldn't be additional criminal behavior, but it would be a violation of my order. And when he comes back to the court on violation, the court has factors that we look at to determine whether or not to treat that essentially as the kind of violation that would require him to go back to jail.
Okay. Judge, yesterday we had an extended conversation of your sentencing of a man named Keith Hodges, a fentanyl kingpin. That sentencing occurred in 2018. You had very detailed recall of that sentence. To my knowledge, that's the only time anyone's asked you about Mr. Hodges' sentence. You've been asked repeatedly over the last 2 days about the Hawkins case. It's been in the news, as Senator Durbin has cited, for days on end. This resentencing happened in 2019, and now you're saying you don't have any recollection of it. Let me see if I can refresh your recollection. This is the order you signed, Judge, on April 17th, 2019, in USA v. Hawkins. And it says that you concur with the recommendation of the probation office to return him to a residential reentry facility for 180 days and to engage in various kinds of computer monitoring and computer monitoring and search. There's your signature over there, Judge. You really don't remember what?
Senator, that is a very, very common thing that judges do. I've sentenced over 100 people, and supervised release, which is the kind of post-incarceration condition that judges ordinarily impose, is something that's done on a standard form, which is what that is.
I understand you've done a lot, Judge, but none of them have been the centerpiece of your hearing for the last 2 days. Do you really expect this committee to believe that you don't remember what happened in this Hawkins case when it came back before you?
Yes, Senator, I do expect you to believe that's my testimony.
Well, I don't find it credible, Judge. It's been in the news for days. Senator Durbin has cited it being in the news for days. You've been asked about it probably more than any other case you've ever had. And I just don't find it credible that you weren't prepared for that matter in 2019. You know what I think? I think he got caught with child pornography again, and he wouldn't have if he had been in prison for the 8 to 10 years the guidelines called for in 2013 when you first sentenced him. Let's turn, though, to your work for detainees at Guantanamo Bay. First off, let me just ask, do you think most detainees at Guantanamo Bay were mostly terrorists or mostly I don't know, innocent goat farmers?
Senator, it's impossible for me to answer that question. The people at Guantanamo Bay had been accused by the government of engaging in terrorist activities and therefore classified by the executive branch as enemy combatants.
Okay, do you think America would be safer or less safe if we released all the detainees at Guantanamo Bay?
Senator, I'm trying to figure out how to answer that question. 9/11 was a terrible attack on our country, and the executive branch, pursuant to authority that the Supreme Court said it had, designated people as enemy combatants and sent them to Guantanamo Bay. The Supreme Court also said that anybody who was so detained could seek review of their detention. And as a federal public defender, my role and responsibility was to make arguments in defense of the Constitution and in service to the court that was trying to assess, based on the authority given to it by the Supreme Court, whether or not people were adequately classified, what the legal circumstances were, how these habeas petitions were going to be processed. This was a series of legal challenges in a novel environment that federal public defenders and lawyers across the country were engaged in helping the court to evaluate so that we can understand what the Constitution required in this time of emergency.
Okay, so no opinion on whether America would be safer or less safe if we released all the detainees from Guantanamo Bay?
Senator,
Okay.
America would be less safe if we don't have terrorists out running around attacking this country. Absolutely. America would also be more safe in a situation in which all of our constitutional rights are protected. This is the way our scheme works. This is how the Constitution that we all love operates. It's about making sure that the government is doing what it's supposed to do in a time of crisis. As Justice Gorsuch said, the Constitution is not suspended in times of crisis. The government still has to follow the rules. And so criminal defense lawyers make sure that in times of crisis, the government is following the rules.
Okay, let's turn to the actual cases. How many of these terrorists at Guantanamo Bay did you represent?
When I was a defender, 4 cases were assigned to me in our office. I don't know how many cases came into the office in total, but
You personally had 4.
I was assigned to them along with another defender who worked on the same cases. She was more senior. She did all of the sort of fact gathering related to the cases, and as an appellate defender, I worked on the legal arguments.
Okay. Did you ever represent any of the detainees at Guantanamo Bay when you were not a public defender?
One of the people who I'd represented while I was in a federal defender, his case got spun off and taken up by a law firm. Law firms around the country were also engaged in this work.
I'm well
at the
aware of what
time.
law firms were doing at the time.
Yes. And I left the federal public defender's office. I joined a law firm, and one of the people that I had represented was now at that law firm. They had him as a client.
That's Mr. Al-Salwam.
Al-Qatani
Al-Qatani was the one.
was the one who
Just coincidentally, both he and you went to Morrison and Foerster.
Yes, Senator.
Okay. What about Mr. Al-Salwam?
I don't know what happened to Mr. Al-Salwam.
You were listed as counsel for 2 years during your time at Morrison and Foerster.
what happens is when you leave from any place, firms or government service, you have to let the court know, or their records reflect where you are in the system, and not so much the case in terms of your address.
So to go back to Mr. Al-Qahtani,
Yes.
He just coincidentally, it's a small world, went to Morrison and Foerster at the same time you did, and then you represented him, and you did file multiple motions on his behalf.
So I don't know if it was at the same time. I'm not sure.
But you did file multiple motions for him,
I only
2008 and 2009.
I don't recall whether it was multiple, but he was still at the habeas stage of the process. And I don't know when he came, because the partners who picked up the case were in Los Angeles. I was in Washington, D.C. They contacted me to say, oh, we see on the docket that you had previously represented him, and now you're with our firm. Will you assist us with looking at these briefs, working on these briefs? There were many lawyers who were working on the filings that you're talking about.
After you left the public defender's office, did you continue in your representation of any other client you had at the public defender's office?
I didn't continue my representation of any client. I left the federal public defender's office and then picked up Mr. Al-Qahtani through the circumstances that I talked about, and there were no other clients that I represented in that way.
I have to say, that sounds like continuation. You represented him at the public defender's office, and then you represented him in private practice as well. And you're telling us that's the only person you represented at both the public defender's office and in private practice?
Yes.
So you didn't continue to provide any kind of pro bono work for murderers or rapists or anyone else, but you did continue to represent this terrorist at Guantanamo Bay?
When I got to the firm and they told me that the case was there, and they recognized that I was at the firm and had previously worked on the case, and by they I mean the partners in the firm, they asked me as a member of the Supreme Court and appellate group of the firm, which is what was my practice, if I would help review and work on some of the briefing that they were submitting on his behalf, given my familiarity with the case.
Were you representing him pro bono at Morrison and Foerster?
The firm takes on pro bono representations, which means that the person isn't paying. And
let's turn to your amicus briefs. You had two briefs in Guantanamo cases, one for a think tank, one on behalf of a group of former judges. I think, as anyone who's done amicus work knows, sometimes the client seek out the lawyer, sometimes the lawyer seek out the client. For either of those amicus briefs, were you involved in any way in seeking or recruiting those clients or suggesting the idea for an amicus brief in the first place?
No, Senator.
Were both of those briefs done on a pro bono basis?
Yes, because the Supreme Court and appellate group in a law firm has paid clients and also has pro bono clients. And the briefs that I worked on were on the one brief was 20 former federal judges who wanted to make an argument in the Boumediene case that was in the Supreme Court. And one of them was a partner at my law firm. She was a former federal judge whose idea it was, and she knew the other judges and wanted our group to work on the brief. The other was not just one think tank. It was the Cato Institute, the Rutherford Institute, and the Constitution Project, an ideologically diverse group of nonprofits who wanted to make arguments in another case that the Supreme Court had taken up related to these issues, because all of this was novel and a lot of issues were being evaluated by the Supreme Court regarding the scope of executive authority during this time of crisis.
Okay, so you've done pro bono work for or on behalf of detainees at Guantanamo Bay. Have you ever done pro bono work for the victims of terrorism?
Senator, I'm not aware of any such cases in my law firm. I was in a group of lawyers that was often approached to ask would you file a brief for some group? And I'm not aware that any victims of terrorism asked our firm to participate.
So we've talked a lot about the people you represented. Let's talk a little bit about the defendants in those cases and how you characterize them. I'll remind you that those were the President, the Secretary of Defense, and active duty Army officers. Senator Graham and Senator Cornyn said that you called them war criminals. You disputed that, and Senator Durbin has repeatedly denied it as well. And I'll concede you didn't use those exact words. You didn't say war criminals. But you did say in multiple court filings that they committed acts that constitute war crimes. I'm sorry, but I got to confess, I don't understand the difference between saying someone is a war criminal and saying they've committed acts that constitute war crimes. So can you explain that difference to me?
Yes, I will. Thank you for the opportunity. So when you file a habeas petition under our law, you can't file it against the United States because of sovereign immunity. The way our law works, you have to file it against individual officers in their official capacity. That's the way in which you're able to file a habeas petition. So whoever is the executive at the time becomes the named party in the brief. And a habeas petition is like a complaint in a civil case. It's making allegations to begin the litigation about the person's detention.
But Judge, official capacity, personal capacity, all that is just a bunch of procedural gobbledygook. These are the people that you said committed acts that constitute war crimes.
With respect, Senator,
I just don't understand the difference between calling someone a war criminal and saying they committed acts that constitute war crimes.
With respect, Senator, they were not sued in their individual capacity. We weren't making allegations about those individuals. And in fact, over the course of the case, the names changed. So later on, the habeas petition became against President Obama because he then became the executive for the purpose of the habeas petition.
I'm well aware that name changed. It probably changed from Bob Gates or from Don Rumsfeld to Bob Gates as well. But they were not the ones in office. They were not the ones who were overseeing the government when you filed these suits and you said they committed acts that constitute war crimes. I don't understand how you expect this committee to believe that there's a difference between saying someone's a war criminal and saying they committed war crimes.
Thank you for the opportunity to explain, Senator. One of the allegations that had been publicly reported with respect to the group of people who were in Guantanamo Bay was an allegation concerning the use of torture. And when you make that allegation, you bring it under laws that themselves constitute crimes of war. That's the way in which the law works. So if you're writing a habeas petition and you say, upon information and belief, Mr. Al-Qahtani was tortured, that allegation is made under a law that says that there was a war crime that occurred as a result of that torture, and you're making that allegation against the United States, but because you can't sue the United States, the actual petition is named in the name of whoever's leading the United States at the time. So later in the course of this, it moved from President Bush, Donald Rumsfeld, to President Obama. It's not about the individual. It's about the allegation that that Mr. Al-Qahtani, upon information and belief, had been tortured in the lead up to his detention.
I don't know, Judge. Sounds like a debate about how many terrorists can dance on the head of a pin to me.
Thank you, Senator Cotton. Ask unanimous consent to enter a letter in the record from 9 former national security officials defending Judge Jackson's Guantanamo representation. The signatories include former Attorney General Loretta Lynch, Department of Homeland Security Secretary Jay Johnson, and the former Judge Advocate General of the United States Navy, Senator Booker.
Thank you very much.
Judge, do you remember a man named Keith Young?
Yes.
Good. For the benefit of my colleagues, let me quickly cover the basics of his case. You sentenced him in 2018. Keith Young was a career criminal who had previously been convicted of trafficking cocaine. In 2017, he was running a drug business in his house where his children lived and was found with 2 1-kilogram bricks of heroin worth hundreds of thousands of dollars, along with a gun, ammunition, thousands of dollars in cash, and equipment to cut and package heroin for retail sale. The drug lab also confirmed that there was fentanyl in both bricks of heroin. And in one of the 2 bricks, there was actually more fentanyl than there was heroin. While at the D.C. jail awaiting trial, Young bragged about his arrest and about how he was a kingpin. Those are his words, not mine. Kingpin. He was even recorded calling his wife and brother to give them instructions on collecting drug money from people for him. The prosecutors filed a notice of Young's criminal history, which meant he faced a mandatory minimum of 20 years. You did not seem to like that, Judge. In fact, at his sentencing, you said, this is a quote, that you shared his frustration, that you couldn't give him a lighter sentence. I was shocked to see this in the transcript. I was also shocked that you apologized to this drug kingpin for having to follow the law. You literally said that you didn't think 20 years was fair. This is the quote, "And for this, I am sorry, mostly because I believe in second chances." You apologized to this career criminal, a drug kingpin. In his own words, he was not some low-level, first-time drug offender who made a bad choice. That was in 2018. But in 2020, you got a second chance. After Young's sentence, Congress passed something called the First Step Act, which reduced sentences for serious drug traffickers with lengthy criminal records. During the pandemic, lots of criminals like Keith Young tried to twist the First Step Act's compassionate release provision, which was intended for terminally ill elderly inmates to get early release and blame it on COVID. You had none of that, and that's good. You rightly said at his resentencing hearing, quote, "COVID-19 is not only present in prisons," and you said that Young's past as a smoker and his claim of various other health issues did not entitle him to early release. If you had stopped there, I would have cited that as a great example of how you follow the law and made a well-reasoned decision. Unfortunately, you didn't stop there. You said in the resentencing that, quote, "Congress did not make their changes under the First Step Act retroactive. But that if they had, then you could have given him a reduced sentence." But then you said, no matter what the law says, and this is a quote, Judge, "The court feels as though in this moment, per Mr. Young's compassionate release motion, the court is being called upon to evaluate the length of his sentence under the revised section of the law in the First Step Act, and so it is almost as if I am sentencing him today. And if I were to do so, he would face a sentence that would be well below the 240 months that Mr. Young received. And so for that reason, I will grant Mr. Young's motion." Judge Jackson, before you granted this fentanyl kingpin's motion to reduce his sentence, did you contact any of the victims from his case?
Senator, thank you for allowing me to address Mr. Young's situation.
I asked a simple question. Did you contact the victims in his case or not?
Senator, Mr. Young was not released. His sentence was reduced, and I did not contact the victims in his case because there were no victims. He committed a crime, a drug crime. There were no identifiable victims in his case.
Drug crime is not a victimless crime. 100,000 Americans were killed by overdoses.
Understood, Senator, but there was no one to contact because there were no identifiable.
Judge, you just acknowledged that you did not release him. You're right, you didn't release him. He filed a motion for compassionate release. You denied that rightly. But you reduced his sentence. He didn't file a motion to reduce his sentence. He wasn't eligible for a reduced sentence under the First Step Act because it wasn't retroactive towards him. You took a motion for compassionate release to get out of prison and turned it into a motion to reduce a sentence. So he's going to be released 7.5 years earlier, years from now. Last week, Judge, when we talked in our office, you talked about a lot about judicial restraint. Is transforming his motion for compassionate release into a motion to reduce a sentence for this drug trafficking kingpin an example of judicial restraint, Judge?
Yes, Senator, it is, and I will explain how. Mr. Young, as you say, was facing originally a sentence of 20 years in prison, which I imposed. I tried Mr. Young, who went to trial, primarily because he was facing such a long penalty. I looked at the evidence in his case. He was absolutely the kingpin that you're talking about. But the way that our laws work, the 20-year sentence that he received for the amount of heroin that he had was increased based on a sentence that he received, I think it was 10 or 15 years before. He had no criminal history between the old sentence. Forgive me, I can't remember exactly what it is, and I'm sure people will look it up. But 10, 15 years before, he had some minor sentence. Then he had this really obviously serious, terrible sentence. And the government filed what is called an 851, which is an enhancement based on his really, really old prior criminal history. I followed the law, which said that he had to go to jail for 20 years. It would have been more like 10 years if the government hadn't taken into account his very old criminal history. But I said, fine, this is the law. I'm following it. You're going to jail for 20 years. In the interim, COVID happens. We get lots of compassionate release motions, and there's a statute that Congress has enacted which allows defendants to seek compassionate release, to seek reduction of their sentence, not just release, reduction, release, some adjustment to their penalty under the law if there are extraordinary and compelling reasons to do so. That's the quote from the statute, extraordinary and compelling reasons. Doesn't say anything more narrow than that, although you do have to look at the guidelines related to compassionate release, all of which I did related to his motion. And he argued several things. He argued his smoking, his asthma. These were reasons, he said, for compassionate release, and I disagreed. What I did find extraordinary and compelling is the fact that between the 20-year sentence that I gave him originally and the compassionate release motion that he filed, Congress changed the law. Congress decided that the old penalty, the old crime, was no longer eligible for the increased, so that a person who was convicted at the time of his compassionate release motion for doing exactly what Mr. Young had done would not get a 20-year sentence. That would not be lawful for a person at that moment. And one of the things that Congress says to the judges is care about unwarranted sentencing disparity. Care about the fact that the person you're sentencing is being treated differently than someone else who committed exactly the same crime. And I understand it wasn't retroactive in the sense that everybody, absent a compassionate release motion, wouldn't have been eligible for resentencing. But here I have a defendant before me and all of the factors that Congress has asked me to take into account, and a compelling argument that there were extraordinary and compelling circumstances, that is, a change in the law, that would create unwarranted sentencing disparity if I didn't take account of it. And so what I determined under those circumstances is that I would resentence Mr. Young to the penalty that Congress had decided was the appropriate penalty for the conduct that he committed as of the time of his motion.
Judge, Congress did change the law after sentencing in the First Step Act. That was a terrible mistake. Congress specifically did not make that change retroactively. And you saw that, and you thought it was extraordinary and compelling, even though Congress specifically did not make it retroactive. You chose to rewrite the law because you were sympathetic to a fentanyl drug kingpin whom you had expressed frustration at having sentenced him to his 20-year sentence in the first place. You twisted the law and you rewrote it so you could cut the sentence of a drug kingpin. That's what you did, Judge.
Respectfully, Senator, I disagree. Congress provided judges through the compassionate release motion mechanism with the opportunity to review sentences. Congress, prior to the compassionate release mechanism being enacted, a judge who imposed a sentence would have no opportunity to revisit. In Mr. Young's case, the question was, with this compassionate release motion, under a circumstance in which Congress had changed the law, was that an extraordinary and compelling circumstance to revisit his sentence? And I made a determination that it was.
So I suppose then, if you're confirmed, we can just count on you to always rule in favor of retroactivity, no matter what the facts of the case are, because it was a blatant rewrite of the law here, so you could reduce the sentence of a drug kingpin if you didn't like sentencing to 20 years in the first place.
No, Senator, it was not.
Senator Booker. Thank you, Senator Coons. Senator Cotton.
You know, Democrats in the committee and Judge Jackson herself have repeatedly said that senators should look to her record to see what kind of justice she would be. Although some of our Democratic colleagues now claim that it's engaging in conspiracy theories to dare to ask Judge Jackson about that very record. Her record and her answers are clear. Judge Jackson may be a fine woman, but she has built her career as a far-left activist, and that didn't change when she put on a black robe 10 years ago. In fact, Judge Jackson remains more of a defense attorney for criminals from the bench than a judge. Across the board, Judge Jackson's average sentences for criminals are 34% lighter than the national average for criminal cases, and 25% lighter than the average on her own old court, the D.C. District Court. And the child pornography cases are just the most sensational examples of her soft-on-crime attitude. In her hearing, she talked about how deeply disturbing these cases are and how she always gave the criminals a really serious talking to for their possession and distribution of videos of young children being sexually abused. But a serious lecture is not a serious sentence. These aren't just numbers, these are criminals with real victims. And they go on to victimize again because Judge Jackson lets them off early. One of those criminals was Wesley Hawkins, who was a serious child pornography offender that Judge Jackson let off easy. The sentencing guidelines recommended 8 to 10 years in prison, 8 to 10 years. Judge Jackson gave him just 3 months. And that's only 1/6 of what her own probation office recommended. And a few years later, when Hawkins would still have been in prison if she had followed the guidelines, he did something else that got him 6 more months in custody, twice the original sentence. When all 11 Republicans on this committee sent a letter asking for details of what happened, Judge Jackson refused to provide any further information. I guess so much for looking at her record. Of course, her leniency isn't limited to these child pornography cases. In 2017, Judge Jackson apologized. She apologized to a fentanyl kingpin with a history of drug trafficking because she couldn't find a way to give him less than the mandatory minimum sentence imposed by Congress. And she felt bad about being so mean to a fentanyl kingpin. A couple years later, though, she found a way to twist the law to resentence him below the mandatory minimum sentence by making the First Step Act retroactive, even though Congress had explicitly chosen not to make it retroactive. She also said that there were no victims in the case. Fentanyl trafficking is not a victimless crime, and anyone who doesn't understand that does not belong on the Supreme Court. Judge Jackson also granted compassionate release to a man who brutally murdered a deputy U.S. Marshal by shooting him on the steps of a church at a funeral. He was repeatedly denied parole, and in prison he had racked up infractions for things like threatening prison staff and possessing a dangerous weapon. Not exactly a reformed saint. Judge Jackson granted him compassionate release anyway because he had high blood pressure. In 2013, a sex offender had repeatedly raped his 13-year-old niece and was arrested for falsifying sex offender records to avoid telling the government where he was living, or that he was working at a daycare, despite a restriction on his contact with children. The government asked for him to go to prison for 2 years. Judge Jackson gave him just 1 year. During that second year, when he should have been in prison, yes, he went on to try to rape again and then bribe the victim with $2,500 to recant her testimony. Judge Jackson habitually sympathizes with criminals over victims. These are just a few of the many cases in Judge Jackson's record that all make one thing clear. If you are a criminal, you would be lucky if your case is assigned to Judge Jackson. If you are the victim of a crime or anyone else seeking justice, you better hope your case got assigned somewhere else. As a trial judge, Judge Jackson could only give the benefit of the doubt to one criminal at a time. As a Supreme Court justice, she would be able to give the benefit to criminals nationwide in all cases. Let's consider her terrorism cases. She seems to have a real interest in helping terrorists. Now, it's true that you shouldn't judge a lawyer solely for taking on an unpopular case, and defending criminals doesn't necessarily make someone ineligible to be a judge. But during the Bush administration, representing terrorists was all the rage in liberal legal circles. These were not unpopular cases, but instead, lawyers at liberal law firms and public defender's office fought with each other to be able to work for these terrorists. Judge Jackson represented 4 terrorists as a public defender, one of whom she continued to represent in private practice. She also argued in favor of terrorists in 2 other cases in amicus briefs while in private practice. Her backers try to have it both ways. On the one hand, they say this is all just assigned work, but on the other hand, they celebrate her as a hero for volunteering for so-called assigned work. Well, whether it was assigned or volunteered, the fact that Judge Jackson didn't do a very good job. In 3 of the 4 cases, her filings were identical, word for word, comma for comma. She alleged identical facts and legal arguments in every one of those cases. The only differences was the swapped out name and case numbers. So let's look at those terrorists. One of her terrorist clients designed the prototype shoe bomb that was used in an unsuccessful attempt to blow up a passenger airplane. Another of her terrorist clients planned and executed a rocket attack on U.S. forces in Afghanistan, and another of her terrorist clients was arrested in a raid on an al-Qaeda explosive training camp. Yet in every case, she claimed that her clients had nothing to do with terrorism and had never been affiliated with al-Qaeda or the Taliban, despite having no reason to believe that her alleged facts, copied and pasted from one brief to the next, were true. Judge Jackson also has a habit of refusing to answer simple common sense questions in her hearing and in questions for the record. Famously, when Senator Blackburn asked her what a woman was, she claimed that she had no idea. I asked her who has more of a right to be in the United States, new American citizens who follow the rules, waited their turn and came the right way, or illegal aliens whose very first act in the United States was to break our laws and who continue breaking them every day that they remain here illegally. Judge Jackson declined to answer. And when I asked Judge Jackson whether releasing Guantanamo Bay terrorists would make us more safe or less safe, she again pretended to have no clue. And of course, she refused to take an opinion on court packing, unlike the justice she would replace, Stephen Breyer, or the sainted Ruth Bader Ginsburg. Judge Jackson plays ignorant not because she doesn't know these answers, but because her liberal judicial philosophy is based on denying reality and trying to invent a new reality through the brute force of will as a judge. Judge Jackson's attempts to invent a new reality demonstrate a willingness to skirt the law when it doesn't fit her preferred outcome. Not only did she engage in what the Sixth Circuit called an end run around Congress to make the First Step Act retroactively reduce the sentence of that fentanyl kingpin I mentioned earlier, she also worked hard to strike down a Trump administration policy of removing recently arrived illegal aliens. The law passed by Congress granted DHS, quote, sole and unreviewable discretion on the issue. But Judge Jackson inserted herself to strike down what she called, quote, a terrible proposal by DHS, as if it's the judge's place to decide what is and is not a terrible immigration proposal. The D.C. Circuit Court, no hotbed of conservative activism, reversed her and noted that, quote, There could hardly be a more definitive expression of congressional intent than the clear language of the statute she disregarded because she didn't care. She had an anti-Trump op-ed to write in the form of a judicial opinion as part of her audition for the political left to put her on the Supreme Court one day. Last week, Senator Durbin said that despite Judge Jackson saying explicitly that she doesn't have a judicial philosophy, she does have one, but, quote, you have to take the time to read any or all of her 578 opinions that she has issued. And for once, Senator Durbin and I see things similarly. Judge Jackson has a judicial philosophy, and that philosophy is obvious from her record on the bench. Judge Jackson will coddle criminals and terrorists. She will twist and ignore the law to reach any result that she wants. That is not what we need from a Supreme Court justice, and that is why I will vote no on her nomination.
Senator from Arkansas.
The Senate will soon vote on the nomination of Judge Ketanji Brown Jackson to be Associate Justice of the Supreme Court. I will vote against her nomination. Judge Jackson may be a fine woman, but she is a dangerous judge. She built her career as a far-left activist, and it didn't change when she put on a robe 10 years ago. She personifies activism from the bench. She has crusaded to undermine criminal sentences, and she cannot be trusted to interpret the law or the Constitution as written. Judge Jackson's record makes clear that her brief stint as a criminal defense attorney wasn't motivated merely by a devotion to equal representation of all. It was part of a deep commitment to leniency for criminals. Indeed, she has continued to act as a de facto lawyer for criminals from behind the bench, as she did from in front of it. Judge Jackson's average sentences for criminals are 34% lighter than the national average for criminal cases, and 25% lighter than her own court's average, the D.C. District Court. Disturbingly, some of the most sensational examples of her soft-on-crime attitudes are cases involving child pornographers. She has given more lenient sentences than recommended by the sentencing guidelines in every single child pornography case where the law allowed it. Every single one. Every time. Individuals sentenced by Judge Jackson for child pornography possession receive, on average, 57% lighter sentences compared to the national average. For child pornography distribution, the sentence is 47% lighter than the national average. These aren't just numbers, these are predators. And they go on to commit more of the most heinous crimes imaginable because Judge Jackson lets them off so easy. In one case, Judge Jackson gave child pornographer Wesley Hawkins just 3 months in prison when the sentencing guidelines recommended 8 to 10 years. 3 months versus a recommended 8 to 10 years. Judge Jackson even gave him a sentence that was 1/6 as long as what her own probation office recommended. And a few years later, when Hawkins should have still been in prison for his original offense, he did something else. They got him 6 more months in custody. That's twice as long as his original sentence. When all 11 Republicans on the Judiciary Committee sent a letter asking for details of what happened to justify this new sentence, Judge Jackson refused to provide any further information. So much, I guess, for looking at her record, as she urged us to do. Her leniency isn't limited to child pornographers either. In 2017, Judge Jackson apologized. She apologized to a fentanyl kingpin, his own words, kingpin, because she couldn't find a way to sidestep the law to give him less than the mandatory minimum sentence. She was very sorry that she had to give him such a long sentence. But I guess where there's a will, there's a way. A few years ago, she found a way to re-sentence this self-described kingpin below the mandatory minimum sentence. Through a completely made-up reinterpretation, Judge Jackson made the First Step Act retroactive for this fentanyl kingpin, something Congress had explicitly tried to avoid when it passed the law. This was judicial activism, plain and simple. In her testimony, Judge Jackson claimed that there were no victims in that case. She's wrong. Fentanyl trafficking is not a victimless crime, and anyone who doesn't understand that doesn't belong on the Supreme Court. In another case, Judge Jackson granted compassionate release to a man who brutally murdered a deputy U.S. Marshal on the steps of a church at a funeral. While in prison, this cop killer threatened prison staff and was caught in possession of a dangerous weapon, not exactly a model inmate. He was repeatedly denied parole, yet Judge Jackson granted him compassionate release because he had high blood pressure. In yet another case, a career criminal assaulted a deputy U.S. Marshal with a deadly weapon while resisting arrest. This was the third time that this criminal had assaulted law enforcement officers, the very officers who risked their life to keep judges like Judge Jackson safe. Judge Jackson didn't just sentence him below the government's request or the sentencing guideline range. She gave the criminal less time than even the criminal himself had advocated. You can't make this stuff up. In 2013, a sex offender who had repeatedly raped his 13-year-old niece was arrested for falsifying sex offender registration records to avoid telling the government where he was living and that he was working at a daycare. The government sought a 2-year prison sentence, but Judge Jackson gave him just 1 year instead. And during that second year, when he would have been in prison, he tried to rape again and then bribed the victim with $2,500 to recant her testimony. This dangerous sex offender was convicted of obstructing justice, yet when presented with a do-over, Judge Jackson sentenced him to just 24 months in prison for those violations. Now, I wish I could say this was to her credit because, to be fair, 24 months was the sentence recommended by the government, but she ensured her order in that sentence would run concurrently with the sentence in local D.C. jail, so he'd only end up serving 1 year instead of 2. Judge Jackson habitually sympathizes with criminals over victims. These are just a few of the many outrageous cases in Judge Jackson's record. The takeaway is crystal clear. If you're a criminal, you'd be lucky to have your case assigned to Judge Jackson. If you're a victim or anyone else seeking justice, you should hope that your case is assigned to literally any other judge. As a trial judge, though, Judge Jackson could only help one criminal at a time. As a Supreme Court justice, she would be able to benefit criminals nationwide in all cases. Judge Jackson's far-left activism extends beyond crime as well. Not only did she engage in what the Sixth Circuit called an end run around Congress to retroactively reduce the sentence of that fentanyl kingpin I mentioned earlier, she also worked to strike down a Trump administration order expediting the removal of illegal aliens on equally specious legal grounds. The law passed by Congress granted the Department of Homeland Security, quote, sole and unreviewable discretion to decide which illegal alien should be subject to expedited removal. Nonetheless, Judge Jackson inserted herself to strike down what she called, quote, a terrible policy by the Department of Homeland Security. Well, I regret to inform Judge Jackson it is not her role in our system to decide whether immigration policy is good, bad, terrible, or any other adjective she wants to use, only whether it is lawful and authorized by law. And of course, the D.C. Circuit Court, which is not exactly a hotbed of conservative jurists, agreed and reversed Judge Judge Jackson's decision, noting that there are, quote, could hardly be a more definitive expression of congressional intent than the language in that law that she disregarded. But Judge Jackson didn't care. She had an anti-Trump op-ed that she wanted to write in the form of a judicial opinion. Judge Jackson has also shown real interest in helping terrorists. Now, it's true that you shouldn't judge a lawyer for being willing to take on an unpopular case, but you can certainly learn something about a lawyer from the cases they seek out. And for Judge Jackson and her friends in the liberal legal profession, these cases were not unpopular at all. Judge Jackson represented 4 terrorists as a public defender, one of whom she continued to represent in private practice, voluntarily. And she voluntarily filed multiple friend of the court briefs on behalf of terrorists while in private practice. To make matters worse, she apparently didn't even bother when she was representing these terrorists. She didn't bother to establish a reasonable belief that what she filed with the court was factually true. 3 of her 4 case filings were identical, word for word, comma for comma. She alleged identical facts and legal arguments in each case. The only differences between the briefs were the names and the case numbers. In every one of those cases, she claimed the terrorist had never had any affiliation with the Taliban or al-Qaeda. And in every one of those cases, she accused the Bush administration and American soldiers of war crimes. And who were these supposed innocent victims of American war crimes who, according to Judge Jackson, had nothing at all to do with terrorism? No siree, nothing at all. Well, one of her clients designed the prototype shoe bomb that was used in an unsuccessful attempt to blow up a passenger airplane. Another planned and executed a rocket attack on U.S. forces in Afghanistan. And a third was arrested in a raid on an al-Qaeda explosives training camp. Yet in every case, she claimed that none of them had anything to do with terrorism. Not a thing. Totally innocent, just goat herders who were picked up by marauding American troops. You know, the last Judge Jackson left the Supreme Court to go to Nuremberg and prosecute the case against the Nazis. This Judge Jackson might have gone there to defend them. Judge Jackson also refused to answer one common sense question after another. For example, when Senator Blackburn asked her what a woman is, she pretended not to know. I asked her who has more of a right to be in the United States, new citizens who followed the rules or illegal aliens whose very first act in the United States was to break our laws. Judge Jackson refused to answer. And when I asked a simple question of Judge Jackson whether releasing Guantanamo Bay terrorists would make us more safe or less safe, she again pretended not to know the answer, even though it's published by the Biden administration. I also asked Judge Jackson if criminals were more or less likely to commit a crime if they knew that they would be caught, convicted, and sentenced. I asked this pretty basic question at least 3 times. It was not a hard question, and yet again, she refused to answer. Judge Jackson also refused to say whether packing the Supreme Court was a bad idea, even though the judge for whom she clerked and seeks to replace Justice Breyer and the late sainted Justice Ruth Bader Ginsburg, neither of whom are known for their conservative views, were both willing to publicly denounce such court-packing schemes by the Democrats. Judge Jackson may feign ignorance, not because she doesn't know these answers, but because liberal judicial philosophy is all too often based on denying reality. As a judge, Judge Jackson has denied that reality again and again. Judge Jackson will coddle criminals and terrorists, and she will twist or ignore the law to reach the result that she wants. That's not what we need in a Supreme Court justice, and that's why I will be voting against her nomination. Madam President, yield the floor.